The program is as follows. After a short introduction on my part, Christophe Gollet will give the main presentation for half an hour. Immediately afterwards, we will hear short comments from Alimata Traoré, Guy Kastler, Titilayo Adebola, and Sangeeta Shashikant. The last 20 minutes will then be devoted to questions and comments from the audience. Ladies and gentlemen, 750 meters. Only 750 meters is the distance between the meeting room in the Palais des Nations, where the Peasant Rights Declaration was negotiated and adopted, and the World Intellectual Property Organization building, where also UPOV, the International Union for the Protection of New Varieties of Plants, is hosted. Only 750 meters. But the two texts, the UPOV Acts on Plant Variety Protection and the Peasant Rights Declaration, seem to be from another world. This can certainly best be explained by the genesis of the two texts. UPOV was strongly co-initiated by breeders' organizations and was negotiated and adopted by 6 countries from Western Europe in the early 60s. The 1991 Act of UPOV was negotiated by just 19 industrialized countries and South Africa. UNDROP, the Peasant Rights Declaration, on the other hand, was initiated by La Via Campesina, which unites small farmers from all over the world. The text was negotiated in the framework of the UN Human Rights Council, with all UN countries participating. The declaration was finally adopted by a majority vote at the UN General Assembly, with 184 UN member countries participating. Obviously, such different processes lead to different results, and this in turn leads to contradictions. Christophe Gollet will report on these differences in the next half an hour. Christophe Gollet is a senior research fellow and strategic advisor on economic, social, and cultural rights at the Geneva Academy. Since 2009, Dr. Gollet has been providing legal advice to a number of stakeholders in relation to the negotiation, adoption, and implementation of the UN Declaration on the Rights of Peasants and other people working in rural areas. From 2001 to 2008, he was a legal advisor to the first UN Special Rapporteur on the right to food. In that capacity, he participated in the definition of the right to food in international law and published 2 books, including his PhD dissertation on the right to food and access to justice. Dr. Gollet holds a PhD in international relations with a specialization in international law and a double master's in international law and international relations from the Graduate Institute of International and Development Studies. We are very happy to have Christophe with us today. Christophe will not use a PowerPoint for his presentation. Christophe, please, it's your turn.
Thank you very much, François, for the introduction. And it's a great pleasure for the Academy and for myself to organize this first webinar with François and with Apbrebes. I've been working on the right food, as you said, for 20 years now, and on the rights of peasants, and including the right to seeds for let's say, more than 10 years. This presentation is based on a number of publications that I have published in the last 2 years, and they are all available on the Geneva Academy website. I have put the link on the chat, so you can all have access to these publications. It includes a research brief on the right to seeds and intellectual property rights, a manual on the right to seeds in Europe, and a research brief on UNDROP and Swiss foreign policy. With an intern, Lulbari Araya, we are also preparing a a manual on the right to seeds in Africa. So everything that will be said today and discussed can also help us to finalize this manual on the right to seeds in Africa. So in this presentation, we will see that international law offers a number of opportunities for and challenges to the protection of the right to seeds and intellectual property. I will start with a presentation of the right to seeds and intellectual property international law. I will then present their inherent tensions. I will also present the most recent international instruments adopted on the topic, the UN Declaration on the Rights of Peasants and other people working in rural areas, also called the UNDROP. So on the right to seeds in international law, we must start by underlying that for over 10,000 years, peasants have freely saved, used, selected, exchanged, and sold seeds, as well as reused them to produce food. In the last 30 years, these customary rights were recognized in international law. In the Convention on Biological Diversity, the CBD, and its protocols, in the International Treaty on Plant Genetic Resources for Food and Agriculture, the Plant Treaty, in the UN Declaration on the Rights of Indigenous Peoples, UNDRIP, and in UNDROP's Article 19. In the preamble of the Plant Treaty, states affirmed that the rights recognized in this treaty to save, use, exchange, and sell farm-saved seed and other propagating material are fundamental to the realization of farmers' rights, as well as to the promotion of farmers' rights at the national and international level. In Article 9 of the treaty, states committed to implement farmers' rights as appropriate and subject to their national legislation, which can be seen as restrictive. But they also stated that the Plant Treaty provisions should not be interpreted to limit any rights that farmers have to save, use, exchange, and sell farm-saved seeds or propagating material. It is therefore very clear that the provisions of the Plant Treaty aim at protecting customary rights that farmers or peasants have always had. Some words about UNDROP now. UNDROP, so the UN Declaration on the Rights of Peasants, was adopted by the UN General Assembly in New York in 2018 after 20 years of mobilization by La Via Campesina and its allies, and 6 years of negotiation at the UN Human Rights Council in Geneva. UNDROP was adopted by a vote of 121 states in favor, 8 states abstaining, and 54 states who abstained. So 8 states against and 54 states abstaining. It's important to underline that when it was adopted by the UN General Assembly, the General Assembly called all governments to promote universal respect and understanding of UNDROP without making any distinction on the basis of the votes of states during this adoption, which is in conformity with the need for UN member states to implement UN General Assembly resolutions in good faith. Okay, so it was adopted by a large majority of the states of the General Assembly, but there is a commitment, it's a political commitment of the whole General Assembly and then of the United Nations to promote UNDROP. Compared to other international instruments such as the Plant Treaty or the CBD, international human rights instruments such as UNDROP bring at least 2 added values. First, they define states' obligations in a way that is far more precise than those that are contained in other international instruments. Second, they recognize individual and collective rights that can be transformed into legal entitlements in national and regional laws, and that can become enforceable before judicial and quasi-judicial bodies at national, regional, and international levels. I'll take one example, it's the right to land. The right to land has been included in UNDROP, Article 5 and Article 17, And in 2019, the Human Rights Committee, which is a body of the UN monitoring the Covenant on Civil and Political Rights, took a decision in a case against Paraguay in which there was a peasant family, the land of the peasant family was contaminated, and the father died, and the rest of the family, the land couldn't be used anymore. And the Human Rights Committee interpreted the right to home. The right to home is in the Covenant on Civil and Political Rights, and the Human Rights Committee used UNDROP to say that the right to home for peasants include the right to land. Yeah? So it means that now for the 170 countries who are member parties to the Covenant on Civil and Political Rights, the right to home for peasants include the right to seeds. Okay, so it's a right that you can claim at the international level. The same reasoning has been done by the Inter-American Court on Human Rights, which is a judiciary body at the regional level in the Americas. In 2020, against Argentina, same reasoning to interpret the right to life and to interpret the right to property. The Inter-American Court on Human Rights used UNDROP and says that it protects the right to land of peasants. Okay, so in these two cases, UNDROP was used to interpret binding human rights law. Okay, and it will be the same if we have a case on seeds, access to seeds, the right to seeds of peasants. And it will be also because when we discuss rights, most often, very often, or maybe always, it's also linked to the right to food and to many other rights. So a tribunal or regional body or a treaty body at the United Nations could interpret the right to food and say that it includes the right to seeds of peasants using UNDROP. And that makes the right to seeds of peasants enforceable and able to be claimed by peasant organizations at the national, at the regional, and also at the international level. So that's one of the strengths of the human rights framework, and that's why it's important to have UNDROP and Article 19 on UNDROP on the right to seeds. So now what do we have on the last point? What is also important is that in the case of the Human Rights Committee in 2019, Paraguay didn't vote on UNDROP at the General Assembly. So the committee didn't even question that, you know. So it's also another thing that shows that that the UNDROP applies to all states and not only to those who have voted in favor of UNDROP. On the definition of the right to seeds in UNDROP, how was the right to seeds defined in UNDROP? In defining the right to seeds in UNDROP Article 19, negotiators have built on a number of binding international instruments, including the International Covenant on Economic, Social, and Cultural Rights, in which there is the right to food. And this covenant has more than 170 state parties. It also built on the Convention on the Elimination of All Forms of Discrimination Against Women, the CEDAW Convention, which has today 189 state parties. It also built on the CBD and its protocols and on the PREN Treaty. UNDROP provides that states should respect, protect, and fulfill all human rights, including the right to seeds, and it's explicitly again in Article 19. So this respect, protect, and fulfill framework that is you find in UNDROP has been used since 20 years at the UN. The state should respect, it means that it should not do something negative. So for example, taking a decision that would have a negative impact on the right to seeds. Protecting is protection vis-a-vis third parties, for example, companies. And fulfilling is for those who don't have access to seeds, and it includes, for example, the promotion of peasant seed systems in rural areas. So this respect, protect, fulfill typology has been used since 20 years in the UN and has been included in Article 2 of UNDROP and also in Article 19 of UNDROP. So states should respect, protect, and fulfill the key elements of the right to seeds, which include peasants' right to the protection of traditional knowledge, innovation, and practices relating to seeds, peasants' right to equitably participate in sharing the benefits arising from the use of seeds, peasants' right to participate in the making of decisions on matters relating to seeds, and peasants' right to save, use, exchange, and sell farm-safe seeds or propagating material. These 4 elements are taken are based mainly on the Plant Treaty of 2001, and have been included in this Article 19 of the Declaration. UNDROP also provides that states should guarantee peasants' right to maintain, control, protect, and develop their own seeds and traditional knowledge. It was taken from the UN Declaration on the Rights of Indigenous Peoples. Also, UNDROP provides that states should support peasant seed systems and agrobiodiversity, and promote a system for evaluation and certification of peasant seeds with the participation of peasants. It's Article 19.6 and 11.3. So what is very key in this declaration for the right to seed is that it's a commitment to states to better promote peasant seed systems and peasant seeds. While in the last maybe 40 to 50 years, the tendency has been to promote commercial seeds and industrial seeds systems. Now in this declaration, there is a very strong commitment to promote peasant seed systems and peasant seeds. What also is very important is that in UNDROP, Article 2.4, it says that other international instruments, including those relating to intellectual property, should not restrict but rather facilitate the realization of the right to seeds. So other international instruments, including on intellectual property, should not restrict but rather facilitate the realization of the right to seeds. At national level, it's also important that states should ensure the coherence of their agricultural economic development policies with the right to seeds. It's Article 15.5. And they should ensure that policies and laws relating to seeds, plant varieties, and intellectual property respect and take into account peasants' rights, needs, and realities. It's Article 19a. So now some words about intellectual property on seeds in international law. Binding international treaties also protect intellectual property over seeds, in particular the TRIPS Agreement and the UPOF Convention. The TRIPS Agreement, which is the agreement on trade-related aspects of intellectual property rights, adopted at the World Trade Organizations in 1994, provides that WTO members must protect intellectual property over plant varieties either by patents or by an effective sui generis system, a system of its own kind, or a combination of both. It's Article 27 of TRIPS. Some states have chosen patents, and more than 70 states have adopted a model of land breeders' rights protection proposed by the UPOF. UPOF is the International Union for the Protection of New Varieties of Plants. François talked about it, saying that they are also based in Geneva, very close to the Palais des Nations at WIPO. Some word about UPOF. The UPOF Convention was first negotiated, as was also said by François, in 1961, outside the United Nations by 6 Western European countries. UPOF protects the rights of breeders who have created new, distinct, uniform, and stable plant varieties. It's important to underline that the criterion of novelty here does not mean that the varieties were not already known or used, for example, by peasants. Rather, it means that the varieties had not previously been commercialized or registered in an official catalog. It's also important to underline that the requirements of uniformity and stability mean that peasants are excluded from seeking UPOF protection for their varieties, as peasant varieties are by nature unstable and constantly evolving. UPOF grants intellectual property rights to breeders for periods of up to 20 years or more. The UPOF system prohibits peasants from selling protected seeds, and a 1991 revision of the convention, which already applies to some 30 developing countries, prohibits them from exchanging such seeds. Peasants in member countries of UPOF 91 cannot save or reuse seeds of protected varieties except on their own farms in a limited fashion and with due regard for the legitimate interest of the breeder and only provided their government has adopted an optional exception to this effect. So what is called the farmer's privilege is therefore very limited. A word about UPOF in developing countries. We have said that some 30 developing countries have become party to UPOF, some to the 1978 convention and some to the 91 convention. They have often do so as part of a trade agreement with the European Union, the US, Japan, or the European Free Trade Association, EFTA. Some developing countries, including Ethiopia, Malaysia, the Philippines, or India, have chosen to develop their own sui generis systems through which they were able to protect both plant breeders' rights and peasants' rights. So they have made that choice in order to protect to find a balance to protect both plant breeders' rights and peasants' rights. The 2001 Protection of Plant Varieties and Farmers' Rights Act in India, for example, protects plant varieties and breeders' rights as well as peasants' rights to save, use, sow, resow, exchange, share, and sell farm produce, including seeds of varieties protected by plant breeders' rights. The African Union also developed an African model law for the protection of the rights of local communities, farmers, and breeders, and for the regulation of access to biological resources with very similar provisions. Now some words on the tensions between intellectual property rights and the right to seeds. Intellectual property rights pose serious challenges to the protection of peasants' right to seeds. There are no tensions when peasants use only peasant seeds, and you have understood that it's something that states should promote according to UNDROP, the use of peasant seeds by peasants and the support of peasant seed systems. But there are tensions when peasants use farm-saved seeds from varieties or plants protected by intellectual property. In some countries that have adopted laws conforming to UPOF 91, peasants face civil and in some cases even criminal penalties for saving, reusing, and exchanging farm-saved seed from commercial varieties. In other words, quoting Regine Anderson from the Farmers' Rights Project in Norway, it can be said that peasants are penalized for conduct that should be deemed legitimate and which is functional to society's interest in a sustainable agriculture and the attainment of food security.
Christoph, please slow down a little bit for the interpretation.
Okay, thanks. End of quote. These tensions between the right to seeds and intellectual property rights are exacerbated in developing countries where peasants make up a majority of the agricultural population. In such countries, it is clear that sui generis systems of plant variety protection adapted to local specificities are better suited to protecting the right to seeds. Yet, states of the global south, as well as WIPO, continue to put the UPOF 91 model forward in their collaboration with developing countries, as if it were the only model for the protection of intellectual property relating to seeds. In the future, they should stop promoting the 91 Act of the UPON Convention. Instead, they should encourage developing countries to use the possibilities offered by TRIPS to design sui generis systems of plant variety protection adapted to the agricultural and social specificities of each country, and which enable them to protect the rights of both plant breeders and peasants. Now I will end with some words about the primacy of human rights. In international law, in accordance with the UN Charter, international human rights instruments take precedence in the hierarchy of norms over other international instruments, such as those protecting intellectual property rights. According to the UN Charter, the promotion and protection of human rights is one of the main purposes of the Charter. It's Article 1.3. And UN member states pledged to take joint and separate action to promote universal respect for human rights. It's Articles 55 and 56. In its Article 103, the UN Charter also provides that in the event of a conflict between the obligations of the members of the United Nations under the Charter and their obligations under any other international agreement, their obligations under the present Charter should prevail. Okay? So the obligations to promote and protect human rights that are in the Charter prevail over the obligations that states may have in other international instruments, such as those protecting intellectual property rights. Now, a question: are intellectual property rights human rights? While the right to food and peasants' right to seeds are enshrined in international human rights instruments, there is a consensus in the UN human rights system that intellectual property rights are not human rights. During UNDROP negotiation, it was clear that tensions between the two cannot be described as tensions between two sets of human rights guarantees. While peasants' right to seeds is intrinsically linked to the right to food of billions of people, including the most vulnerable living in rural areas, the fact of granting temporary monopoly privileges to plant breeders and patent holders, in many cases corporations, through intellectual property rights cannot be placed at the same level. Many experts describe this situation as the competition between international human rights guarantees on the one hand and commercial interests protected by international law on the other. In its final report, presented in 2009, the International Assessment of Agricultural Knowledge, Science, and Technology for Development concluded that technologies linked with intellectual property rights, such as high-yielding crop varieties, agrochemicals, and mechanization, have primarily benefited the better resourced groups in society and transnational corporations rather than the most vulnerable. When states adopted UNDROP, they decided to place the rights of some of the most marginalized groups, peasants, at the center of their efforts, not corporations. As a consequence, the primacy of human rights over commercial interests protected through intellectual property rights has been underlined in 2 articles of UNDROP, which provide that, first, states should elaborate, interpret, and apply relevant international agreements and standards to which they are party in a manner consistent with their human rights obligations as they apply to peasants. It's Article 2.4. So it means that international instruments, including on intellectual property, should be interpreted, applied, and elaborated in accordance with the rights of peasants. Second, it's Article 19.8. States should ensure that seeds policies, plant variety protection, and other intellectual property laws, certification schemes, and seed marketing laws respect and take into account the rights, needs, and realities of peasants. Okay? These 2 provisions reflect the fact that as higher order norms, human rights do not have to be adapted to trade agreements and national laws and policies. On the contrary, it is trade agreements and national laws and policies that must be adapted to ensure the ongoing protection of human rights. 2 words in conclusion. UNDROP has been adopted to rebalance power relations in rural areas and to guarantee that states respect, protect, and fulfill the rights of peasants who have been left behind in national and international policies. In its mission to strengthen the rights of peasants, UNDROP addressed a number of questions which are fundamental to all, including the preservation of biological and seed diversity. UNDROP implementation is therefore key for redressing legal and policy distortions that have negatively affected peasants, peasant seed systems, and agro-biodiversity. I end with a few recommendations. In accordance with UNDROP and with the binding international treaties on which it is based, states should promote the right to seeds at the UN and in the implementation of the CPD and its protocols, the Plant Treaty, UNDRIP and UNDROP. States should elaborate, interpret, and apply international agreements and standards in a manner consistent with the right to seeds. This implies that they should ensure that the negotiation, interpretation, and implementation of WIPO, WTO, and UPOF instruments do not violate but facilitate the realization of the right to seeds, including peasants' right to freely save, use, exchange, and sell farm safe seeds. States should also ensure that free trade agreements to which they are party do not lead to violations of the right to seed of peasants, of the right to seeds of peasants in their country or in other countries. This implies, as I said, that they should stop promoting UNDROP 91 as if it would be the only model for the protection of intellectual property on plant varieties. Instead, they should encourage developing countries to use those possibilities offered by TRIPS to design sui generis systems of plant variety protection adapted to the agricultural and social specificities of each country, and which enable these countries of the South to protect the rights of both plant breeders and peasants. At national and regional levels, states should ensure that seed policies, plant variety protection, and other intellectual property rights, seed marketing laws, variety registration and certification schemes, largely designed in many countries to meet the needs and interests of the agricultural industry, should respect and take into account the rights, needs, and realities of peasants. That's very important at the national level, but also at the regional level. And that's why we have also a project on the right to seeds in Europe. We have a publication on the right to seeds in Europe that you also have access on the website. And we are working on the manual on the right to seeds in Africa. So the implementation of the right to seeds and will need your support at the international level, at the regional level, and also at the national level. Thank you very much, Francois, and I'm very happy to be with you for this the rest of the webinar.
Thank you very much, Christophe. We will now directly go to some other experts commenting on what we have just heard from Christophe. And I would like to start with Alimata Traoré. Alimata is the president of the Convergence of Rural Women for Food Sovereignty, COFERSA, representing several thousand women farmers organized in a network of rural women's cooperatives in Mali, Africa. The organization is very active in the promotion of biodiversity cultivated for food within the West African Peasants Seed Coordination, COASP. Alimata is also a member of the Biodiversity Commission of La Via Campesina International. Alimata, je te donne le floor. À toi de parler.
Merci, François.
Thank you, François. I think I might have to turn my camera off because I don't have a stable connection. Can I turn my camera off? Yes, we can still hear you. Thank you, François. Thank you for organizing this webinar, because the issue at hand is very relevant. I would also like to thank Dr. Christophe for his presentation. He really did present everything well, so that we can understand everything related to the right to seeds, as well as those issues that are binding on the right to seeds. So I think we have heard what issues are vital for us farmers. And we as peasants have a serious problem, because it is difficult for us to understand all these conventions. It is difficult to understand the content of all these different agreements and conventions. I think there are very few of us that do understand them. So that's a real barrier. There's also the language barrier, because many things are written in languages that peasants do not understand. And then there is the issue of the data. Peasants do not understand everything that is written in these documents. Therefore, I think Christophe mentioned everything that is linked to the right to seeds, the right to food, human rights, and how this is an issue of peasants' rights. So we need to move bearing everything in mind that exists already. Everything that exists on the peasant's rights to seeds. The report is also written in English, so we have not been able to take advantage of it. Even if we translate it using Google or another tool, it doesn't really convey what is essential in the content of the report. So we need access to it. We need to have this information so that peasants can understand their rights and so that they can understand what is being discussed on their rights. When we look at conventions, peasants don't understand them. So how are we going to inform the peasants so that they can use this content and so that they can really say, look, this is our position vis-a-vis this or that agreement. So I would now give the floor to Guy so that he can add to what I was saying. But those are the points that I wanted to underline, and I will come back during the Q&A. Thank you very much, Alimata.
So I think we just heard that the right of peasants, or what I learned from what has Alimata said is that this needs to always include the right to participate, that the right to participate includes also the right to have access to information, and this is all interlinked. I give now the word to Guy Kastler. Guy Kastler worked as a farmer, winemaker, and herdsman cheesemaker engaged in organic farming in the south of France. He is a representative of the European coordination Via Campesina and a member of the Biodiversity Commission of Via Campesina International. Guy, à toi la parole. Merci.
You have the floor.
Bonjour à toutes et à tous.
Thank you. Good afternoon to everybody. Thank you for organizing this webinar and for allowing us to speak on this very important issue. I will not go back to what Alimata was saying, but I would like to share my experience. It's around 15 years that I have been taking part in discussions on treaties, on the Convention on Biological Diversity. I do not speak English. About 90% of peasants do not speak English. All the discussions are in English because this has become the dominant language globally speaking. And I would like to thank the organizers for organizing the interpretation, because otherwise we wouldn't have peasants participating if they cannot express themselves in their mother tongue. So I think a lot has been said. We have a lot of legal experts around the table today. I want to emphasize that the rights of peasants are vital if we want to feed the world's population in the context of climate change, and also with a view to being completely rid of the use of pesticides. Intellectual property rights as they exist now are the main obstacle to us having an agricultural transition to adapt to climate change across the world. That is not to say that it would not be possible to have adapted intellectual property rights. Currently, we are poisoning our lungs, our soils, and the air which we live in. IP rights are private property rights. They allow monopolies to exist and they allow exploitation. There are patents, and that is what we see with UPOV. And you can create a patent following on from having taken a seed from a peasant farm. So as a farmer, I can then sell onto the global market using this patent. Now, currently, first and foremost, we need to have seeds that are adapted to each of our contexts. There are no two places that are identical. And if our plants are not adapted to that context, then they will be even less able to withstand successive climate shocks. Yesterday, it was 35 degrees, today it's 12 degrees centigrade. So you see the huge changes. So there are not a million solutions to having adapted seeds. You need to find local seeds that are adapted to where they are, and then you can use them as breeders, and they will then become increasingly well adapted to climate change. We will also then have seeds that are adapted to our soil rather than to pesticides. And the current intellectual property rights that exist do not respond to this need. Peasants' rights are collective rights, which allow peasants to organize themselves locally so that they can manage this adaptation for plants. Because peasant does not only need to work individually, but they also need to constantly exchange seeds to replenish their seed stocks and to encourage biodiversity, because biodiversity is how we will adapt to climate change. We thought that elite varieties were going to give us greater yields, but actually the only thing that we've done is created varieties that are adapted to pesticides.
To food security, to adaptation to climate change, and to lead the need for locally adapted varieties selected by farmers. I will now give the floor to Dr. Titilayo Adebola. Titilayo Adebola is the theme coordinator for intellectual property law and associate director of the Center for Commercial Law at the University of Aberdeen School of Law. Dr. Adebola is also a senior advisor to the United Nations Special Rapporteur on the right to food. Titilayo, thank you very much. The floor is yours.
Okay, thank you very much, Francois, for the kind invitation and for this excellent webinar on a very important discussion. So I very much enjoyed listening to Christophe's presentation and to the feedback and reactions that we've also had from Alimata and Guy. And some of what I would be saying also resonates with what has been presented. And I will be covering two main points. First, what the Special Rapporteur on the Right to Food envisions for farmers' rights and the interlinkages between that and international law, as well as what we've had historically from the African continent, from the Organization for African Unity, now African Union. And so those two interventions speak to the way farmers' rights, community rights have been centered both at the international level and at a regional level, using Africa as a case study. In his report submitted to the Human Rights Council, pursuant to Council Resolution 4311, the Special Rapporteur on the Right to Food, Michael Fakhri, provides an outline of the direction that he intends for his tenure. And in his vision, he includes four main thematic areas. First, COVID-19, so coronavirus disease, pandemic, and the hunger crisis. We would understand why this has been given priority, considering the ongoing disruptions to food systems around the world as a result of this unexpected pandemic. The second is food systems and global governance, and we would also understand why this has been prioritized, considering the upcoming Food System Summit. The third, which is the concern for our discussions here today, is on seeds and farmers' rights. And the fourth is on rights to food in armed conflict and protracted crises. So I would focus on seeds and farmers' rights. The main point that Christophe has underscored in some of the discussions around the international legal architecture related to plant varieties and farmers' rights is also a core concern in interpreting his vision, that is Michael Fakhri. And here he recognizes that while we can start our conversation with the International Treaty on Plant Genetic Resources for Food and Agriculture, Article 9, because that provides a legally binding international treaty and text on farmers' rights. However, one of the provisions there is that it leaves the implementation to national governments, subject to needs and priorities. Now, we would recognize that farmers' rights predate the international treaty because farmers have been actively involved in conserving and developing varieties and domesticating varieties even before the international treaty. So that is an established position. But starting with this legal text that cements the role of farmers' rights in our international legal framework, the question remains how national governments would interpret farmers' rights. The Special Rapporteur mentions that he understands how we have multiple layers of international treaties, legally and non-legally binding declarations, UNDROP, UNDRIP, the International Treaty on Plant Genetic Resources for Food and Agriculture, the Convention on Biological Diversity that has provisions on traditional knowledge, access and benefit sharing. It's Nagoya Protocol that helps in interpreting fair and equitable benefit sharing. While we have these multiple layers or networks of international treaties, how can these legal texts be defined at the national level? And so further to Alimata and Guy's position, what does it mean for the farmer on the ground? And that is the focus of the Special Rapporteur's report that is due to be published in December of this year. practical examples, positions on what farmers' rights would look like from the frame and perspectives of human rights. So a human rights-centered approach to farmers' rights. And we're going to be working on that, and we look forward to that publication. So I would agree that legal texts might be cloudy and might present a disconnection between the realities on the ground for the farmers, the female farmer that is going to the farm and just wants access to the varieties that she has preserved over the years. What would this UNDROP, for example, or Article 9 of the treaty mean for her? Here we have provisions from the African model legislation for the protection of rights of local communities, farmers and breeders, and for the regulation of access to biological resources, or the African model law that was adopted in 2000. We see that a number of international civil society organizations, such as the Third World Network, GRAIN, the Gaia Foundation, RAFI, were involved in supporting the push and formulation for the African model law. And I just want to state some of the main African common position that informed the African model law. And here it was first, opposition to patents on life forms. So keeping farming communities free to make their own decisions about food production, influenced by their own government, of course. Second, reconciling the provisions of, for example, the TRIPS agreement, the CBD, and the then International Undertaking on Plant Genetic Resources, which predates the international treaty. And third, establishing a system to protect traditional knowledge and benefit sharing. So that was what grounded the African common position that resulted in the African model law. And I'll just mention some important contributions that the African model law has made to our understanding of how international treaties can be translated into domestic law. Here, we have provisions for 3 types of varieties: community varieties, farmers varieties, and then the new breeders varieties, which we know is more mainstream. So community varieties and farmers varieties, here we are recognizing that communities conserve and develop local varieties, and local communities here would be broadly defined as human populations who reside in a distinct geographical area with distinct ownership over their biological resources, innovations, practices, knowledge, and technology. Importantly, the African model law requires states to recognize the rights of these local communities over their biological resources, including plant varieties. Now, another point to note is the African model law recognizes the protection of farmers' varieties, and third, new plant varieties, which is more common placed. I've run out of time, but I'll just point out that things like conditions for protection and scope of coverage are also flexible and not and deviate from the mainstream plant breeders' rights system. So we see a practical example of an instrument that centers farmers' rights and community rights with regards to the conservation and development of varieties. Thank you.
Thank you very much, Titi, and certainly the need for more flexibility, something we see always when new laws are developed, and some countries have the possibility to implement flexible laws, others maybe don't have when they have already been bound by free trade agreements, for example. To end, I would like to give the floor, but not to end the webinar, just to end the comments, then we will go to the discussion. But to end the comments, I will give the floor to Sangeeta Shashikant. Sangeeta is a legal and policy advisor for the Third World Network. She obtained her master's in laws from the University College in London in 2003. And she's also the president of the board of the Association for Plant Breeding for the Benefit of Society, the co-organizer of this event. Sangeeta, please, And Sagita, if you allow me to ask also a question for the beginning, I didn't told you this before, but what I think it's surprising that when we go also to this fora where IP is discussed, for example, to UPOF meetings, we rarely hear anything about this Peasant Rights Declaration. How could this happen? Sagita, please.
So I'll come to that, Francois. I've addressed it in anticipation. You might be asking this question. So just to mention that, so Christophe has laid out, right? When we talk of the right to seed and when we talk about intellectual property, there is tension, and especially with respect to the UPOF system. And we often hear from proponents of the UPOF system, and even sometimes often narrated by governments that want to join UPOF system, that the membership of UPOF is really very important to promote plant breeding activities, to support the development of the seed market. I think we have to unpack this narrative much more, and I would really advise everyone to really, when this kind of assertions are made, to really do some research analysis to unpack this, because the evidence on the ground suggests that actually there is no causal relationship, and I mentioned no causal relationship between the UPOF system and a dynamic seed sector. On the contrary, what we have found, and Apbrebes has a paper on this, is that countries with a non-UPOF PVP system, or countries even without a PVP legislation, have some of the most vibrant seed sectors. Also to mention that the PVP system is quite a new system for developing countries, and the seed sectors are quite developed in many developing countries and are quite dynamic. And a very concrete example here in Asia is that if you look at the number of companies with seed production and breeding activities, they are much lower in Vietnam, for instance, which is a member of UPOF 1991, than, for instance, in India, in Thailand, which are not members of UPOF 1991. And these countries implement alternative systems and recognize farmers' rights. So I think it is important to first highlight that there is no causal relationship. And this is important for us to note because, as we implement the right to seed, there is often this concern that, how does that impact the development of the seed industry? So I think it's good to put it out there. Second point to note is that the UPOF system is a one-size-fits-all regime. And this is coming to your question, Francois. If you look at the UPOF system, it is essentially a copy and paste PVP regime. There is almost no flexibility, if I may say so. You may tweak here and there, but if you want to join the UPOF system, especially now you can only join the UPOF 1991 system, you have to follow the substantive provisions of UPOF. And you cannot just insert any kind of exception. For instance, Malaysia and Philippines had a very modest exception in their PVP law on protecting farmers' rights. And UPOF has responded, you have to delete this because it's inconsistent with UPOF 1991. So there is very little flexibility. And I guess this is because the UPOF system, it has been mentioned, is the result of lobbying of commercial breeders and their lawyers in Europe and other developed countries. Developing countries were not involved in the negotiations. So if you look at the context of this, there is no space to accommodate the implementation of the right to seed. There's no space to accommodate UNROP, if you like, or very, very limited space to accommodate UNROP. And for developing countries, this is very important because access to seeds and propagating material is often heavily dependent on practices of saving, exchanging, and even buying from your local markets. So the second question then is it fit for purpose? There are really serious concerns about how it does not take into account the diversity of agricultural systems, the interests of different actors, and biodiversity related challenges. We hear about climate change, erosion of biodiversity. And then there are all these different international developments, the Convention on Biological Diversity, Nagoya Protocol, UNROP, right? How do we respond to these developments? I think, it is very difficult to do so with UPOF because it's a very inflexible regime. And that is why, if you look at the WTO TRIPS agreement, actually the developing countries really that were participating in this negotiation, even after the TRIPS agreement, really defended the flexibility offered by Article 27.3b. I remember the Africa group in particular put in papers to say, we do not want the UPOF system to be the main system for us to develop a PVP regime, because our needs, our agricultural system, our culture, what we need at the national level is very different from perhaps Germany, France, and Netherlands in Europe. So just to say that, Article 27.3b gives that flexibility. And so the design of the PVP system is left to countries. And there are some good examples in this area. For instance, in India, in Malaysia, there are different elements that can be taken. And, when you design a PVP system, you have got many different options, and then you can take into account all these different international developments, as well as the right to seed. A country can differentiate between crops, horticultural, what is needed for food security, maybe different conditions for granting a plant variety protection, recognizing also that there are different actors within the agricultural system, and you can then also include exemptions that give farmers the freedom to operate. And has this been done? Yes, we have seen this done, and it's been quite successful in the sense that it has not undermined. We see that countries that implement non-UPOF PVP system also get a lot of PVP applications from corporations, because often the concern might be that companies are not going to apply for PVP, but that's not the case. We do see foreign companies coming to apply. So I think we need to really have a bit more in-depth understanding as to the different options